SJC-10307, Cornell versus Dracut Board of Appeals.
Mr. Pilata?
Hello. May it please the Court, Justin Parada for the appellant Paul Cornell. The issue in this case today is what constitutes exercise of a variance under Section 10 of Chapter 40A. So ultimately the Court is going to be asked to craft a rule or craft a series of rules. In this case, the plaintiff, Mr. Cornell, sought to divide his land into two buildable lots. One of those lots had insufficient frontage, and so he applied for and was granted a variance in March 2002. He also needed a variance in order to obtain subdivision approval not required, or A&R status for the locus. In order to obtain A&R status, the statute requires that all the buildable lots have the frontage required by the bylaw. So, Mr.
So if you hadn't gotten the variance, you couldn't have gotten A&R status?
That's correct, and that's written into the statute, Your Honor.
After you got the variance, you did get A&R status?
That's correct.
And to do that, you have to prepare a plan?
You prepare a plan, bring it to the planning board, and the planning board endorses it, approval not required. And it's a very big issue for developers. The subdivision process is very costly and demanding.
But what about Conservation Commission and septic approval? You didn't need an A&R for that.
No, that came later. So once getting the A&R was endorsed and recorded. The next step was to get Conservation and Board of Health approval.
No, my question is, you could have gotten the Conservation approval and the septic approval before you did anything.
That's correct, Your Honor, but I would submit that not a developer in the Commonwealth would do that. A variance is by far the hardest approval to get, and they're sparingly granted. To spend the money, time, and resources
to get a septic?
To get a septic, to get
How much does it cost to get a septic thing? And you can do it, it's
well,
$50?
Well, you have to have a plan designed. To have a plan designed, a septic
You just need
plan.
a location for where you're going to put the house, don't you?
Well, no. To get get an order of conditions from the Conservation Department requires a notice of intent to the Conservation Commission. Septic, if you just want to hook up the sewer commissioner get approval from the sewer commissioner or something like that, it might be easier. But in order to get an order of conditions, you have to give notice to abutters. You have to publish in the newspaper. It's quite a lengthy process, or it can be, and in this case cost several thousands of dollars. In total, the plaintiff spent in excess of $15,000. I'm not exactly sure how much that piece of it cost. But because variances are sparingly granted and hard to get, to go through all the effort of getting all the other approvals you need, and in this case, he only needed two others. In other towns in the Commonwealth, it could be many more. It could be a historic commission. It could be a sewer commission. It could be engineering. To do that prior to getting a variance, which is the hardest thing to get, simply makes no financial sense, because if you don't get the variance, you can't go forward with the project anyway.
Yeah, but it doesn't cost very much to record it. How do you exercise a variance which by Section 11 has not yet taken effect?
Well, I would propose that the appeals court ruling in McDermott has the correct logic on that point. The requirement of recording is to put purchasers and lenders on notice of the status, the legal status of the lot. Arguably, the other purpose of the recording statute, which is Section 11 of 40A, talks about an appeal being, it talks about not being allowed to record until the time for an appeal has run. That's the other purpose. So I would submit that if you went to a building inspector and said, can I have my building permit, and the building inspector said, have you recorded it, and you said no, he would say, well, I can't give you a building permit until you record, but that doesn't necessarily mean that you have failed to exercise the variance, assuming you have done the other things required.
So you would say that you exercise it when you take a substantial step towards doing what?
Well, I would propose that, well, similar to the ruling in McDermott, and that's one of the reasons we're here today, I would propose that there's a couple rules. The first one would be that the granting and recording of the A&R is a step sufficient to establish exercise because of the fact the A&R could not have been granted without the variance, or could not have been endorsed and recorded without the variance. The second rule I would propose is that what the court should do, or what the law should be, is that the time for exercise should be told during the period of navigating the often Byzantine process of getting other approvals from the town in order to develop post-variance. And there is support for that in a case called Belfer versus Building Commissioner of Boston, which is 363 Mass 439. And that case holds that if a landowner gets a variance and the variance is appealed, the time for exercising the variance is tolled until the appeal runs its course. Because it's manifestly unfair for the variance holder to be prejudiced by the time it takes for an appeal to run its course if an abutter or another town body appeals the variance, just as it is unfair for the variance holder to be prejudiced by delays caused by other town boards as he or she waits for those in order to build. And, you know, it puts power in the hands of those boards that they're not authorized to have by statute. Boards of health and conservation commissions have a certain role. Their role is not to second guess decisions made by variance granting bodies and whether or not a variance should be granted. To allow a conservation commission or a board of health, in this case, to delay for months and then have the building inspector say, well, sorry, your year is up, I can't give you a building permit, is unfair to the variance holder. Now, certainly, if a variance holder was able to make his applications to the other town boards and simply sit on those rights, that would be violative of, once the approvals are granted, of the purpose of Section 10, which is to make sure that variances aren't sitting around for years and years and years not being built on.
Couldn't you have sought an extension, though?
It could have sought an extension in this case, in this particular case, but I would propose that that wouldn't solve the problem because the approvals...
Even the 6 months wouldn't have been enough, you mean?
Well, we don't know when the boards would have come back. The boards very well could have come back 6 months in an additional 6 months. The approvals from the Board of Health and the Conservation Commission came after the 1 year, but before what would be 18 months. On the facts of this case, that is true, but it ultimately doesn't resolve the issue as to what would have happened had those town boards come back later than 18 months. He would have been in the same position. And it was discussed a little bit in the appeals court opinion, but there was a second variance applied for in this case, and it was discussed at the hearing before the appeals court. And although there's no bad faith alleged in this case, it certainly puts light on decisions made by other town boards when they certainly know what the variance granting body, in this case the Board of Appeals, has done to second guess those decisions by delaying. The other thing I would point out, if you had gone to the Board of Health and asked for approval and not gotten it and felt like that the Board of Health was wrong in their decision, your only recourse would be to file a lawsuit. The notion that that would take less than a year is pretty hard to believe.
Can I ask you this question? Just to go back to something that Justice Gantz asked earlier. What does Section 11 mean? No variance shall take effect.
Well, I would say it means
What does that mean?
I think it means that you cannot get a building permit until you've recorded. I think that the legislature very easily could have drafted these two statutes to work together if that's what they intended.
Well, does it also mean you can't get A&R approval?
Does it? Well, no, because you haven't. No, it means that you can't get a building permit.
So you could have gotten A&R approval without the variance?
No, because the A&R statute itself requires that both buildable lots in the tract of land have the right amount of frontage.
So how do you get the A&R approval without recording the variance? Doesn't the lot frontage depend upon whether or not you can get a building permit?
No, a building permit may be denied even if you have an A&R. All these things go in a series of steps, and as the amicus pointed out, an A&R does not necessarily make a lot buildable. But in this case, in order to get the...
Yeah, it doesn't, but you need the requisite amount of frontage to get an A&R on a lot.
That's correct. And in this case, he did not, and so he got a variance. He did not record the variance.
He did not record the variance is not effective, and therefore the A&R can't be effective. Isn't that the way it goes?
No, I would disagree because the variance was granted. He had the variance in his hand. He just simply didn't undertake the housekeeping matter of recording it to put other people on notice. The planning board, which granted the A&R, was certainly aware of the variance and knew about the variance and was marked on the plan. Otherwise, the A&R would not have been granted.
What if the variance doesn't involve building?
The variance does not involve building. Well, the variance authorizes a buildable lot with insufficient frontage. There may be other zoning aspects that ultimately prevent you from getting a building permit. Those aren't at issue here. So the steps are to get, if you certainly can get an A&R without a variance, if all the lots will have sufficient frontage. In this case, one of them would not.
No, what I'm talking about is back to your point that what Section 11 means, when it says no variance shall take effect until a copy of the decision is recorded, is that you can't get a building permit until it's recorded.
I would argue
There are other variances that have nothing to do with building permits.
there are other zoning issues. There are other zoning issues that don't have anything to do with frontage. So you may, after everything is complete, have exercise. For example, if everything has been done to exercise, and you went to get a building permit, and the building inspector said, "Well, have you recorded this?" Well, no, go and do it, and once you record, I'll give you your building permit. That doesn't mean he hasn't exercised, because I think if that was the intent, it would have been drafted that way. The other issue is if the building inspector hadn't said that, like in the McDermott case, let's say he had got a building permit and built 2 houses. 10 years later, would the town have been able to say, well, you never recorded this, so you have to tear your houses down? I don't think that's certainly not the intent of Section 11.
But don't you have a bit of a logical conflict here? I mean, I understand your position to be that when you have a variance, it may take you more than a year to get all the approvals you need to actually act upon it and get a building permit, and that therefore we should say you exercise a variance by doing something else. The amicus says we should essentially say you exercise the variance by doing something you could not otherwise do without the variance. And you say, well, the A&R is something that we couldn't
Correct.
do without the variance. But then your exercise, then you're stuck with the problem of it's not recorded, and you've got an A&R based on a variance which is not recorded and therefore has not taken effect. Hasn't Judge Spina sort of revealed sort of a logical inconsistency in what your position is?
I don't think so, because the recording, again, doesn't create the right. The right is created by the grant of the variance, the endorsement of the A&R. The recording of the variance and the A&R puts others on notice. And in other contexts, courts have held that failure to record notice, where there's no prejudice, does not work to undo the fact, or is not fatal to the fact that you have not recorded. So no, the recording does not create any right. Just like all other recording statutes, it's to put people on notice. And it's not indicative of whether or not the right has been created. What's indicative of the right is the grant from the variance granting body, the grant of the A&R, and then ultimately receiving a building permit, which the building inspector would address other issues which aren't inherent in this case.
I'm sort of with you, except this language about shall not take effect. That sounds more than like a notice issue. That the purpose of the recording is more than just to give notice.
Well, again, I would propose that it very easily could have been drafted that way, and it wasn't. And the purpose of, you also see in Section 11, it discusses the rights of appeal. And so I think it's to notify the world, A, that I have a variance, B, that no one's appealed it, and C, that the time for appeal has run. It speaks nothing on a erosion of the rights that have been granted via the variance. All it speaks to is putting the rest of the world on notice that they exist. And in this case, there was no prejudice to anyone because he didn't try to sell the lot or didn't try to get a mortgage on the lot. The substantive right is affected by Section 10, which talks about whether or not the variance is exercised. And again, I would propose that getting the A&R, recording it, making the applications should at least toll the period until he was ready to go to the building inspector and ask for a building permit. There's no question in this case that he could not have gotten a building permit absent those approvals. And so for him to wait, ultimately, for that time, worked as a prejudice against him during this 1 year. And I would also propose that, especially during winters like this one, that also cuts into time to get conservation approval and those types of things.
But let's take your argument that that applying for the A&R is sufficient to say you've exercised it.
Well, I would say having the A&R endorsed by the planning board. I wouldn't say just applying.
So approval is
Approval of the A&R.
Okay, and let's assume you get that approval, but you don't get the other approvals, or you wait in obtaining them for years. the variance is now been exercised timely and therefore it may continue indefinitely?
I would say, again, it would be told during the period of the other approvals. If the A&R is the last approval you need, then I would say, I would propose that you'd have a year from that point. If there are other, and again, in other municipalities, there may be significant other approvals that you need. But I think the A&R works with the other approvals, certainly. In this case, I think you're correct that the fact that there were other approvals needed makes the A&R, the A&R is just one of those. But to go in, get your variance first is the normal course, and it would be foolish to do it any other way. And all these things taken together, and again, even if you weren't going to establish a rule that A, the A&R is enough, or B, making the applications tolls the variance, even in a more ad hoc view of what was done here, which is really what the court did in McDermott, applying for all of these things, spending significant resources, I think should be deemed efficient in this case.
Thank you, Mr. Fuller.
Thank you.
Mr. Hall?
Please, the court. Ray Weicker and I represent the town of Dracut, and we ask that you affirm the decisions of the land court and the appeals court. Mr. Cornell wants the court to apply the McDermott rule of special permits to that of variances, and we ask that you reject that and reject the McDermott holding in that recording
We don't
is...
have to go that far, do we?
You don't have to, ma'am.
Okay.
No.
Well, what's wrong with this argument that the requirement that the variance be recorded is really separate and apart from its exercise? That if there's been, yes, it should have been recorded, but if there's no prejudice, then that requirement can be done afterwards and is sort of a separate issue from whether it's been exercised. Why isn't that okay?
Justice, I'd submit that recording is very important.
Why?
You can't tell if anyone's been harmed, I would submit, because it gives the general public notice that this is out there. For example,
I'm sorry, recording something gives the general public notice, something more than the actual granting of the variance by the town board does?
it would be in the registry of deeds for any prospective buyer, developer, or any other party who was investing in the neighborhood or wanted to buy a property there.
They may have standing to raise that. Why do you? It doesn't make any difference to you, does it?
No, except for the law, Your Honor. I would say the law is expressly clear here that it must be recorded in Section 11 to take effect.
So from your point of view, could we say it wasn't recorded, end of case? We don't have to reach the exercise?
I believe you could, yes. I think the law is very express that for it to take effect, one has to record it within 1 year. And even if...
Doesn't say 1 year.
You're right.
There's statute doesn't say 1 year.
There's
it
no
just
time.
has to be recorded.
You're correct. There's no time period. However, I would agree with the court that you can't exercise it if it doesn't take effect. And I think if you read those two provisions together, then there's no way that this could have been affected. And even if we...
Well, surely counsel says when you go to get a building permit, it has to have been filed at that point or the building permit won't be granted. Isn't that the point? Doesn't it make sense that that's the outer limit of this?
In this case, that's not exactly what happened. However, the building inspector determined that he had not exercised it and didn't address the recording, but that is a logical argument.
So your answer to your brother when he says it's not fair to allow the Board of Health or Conservation Commission to hold up a variance, your answer is, but the variance wasn't recorded.
I would first say that, Your Honor, but I'd also look to the facts here. It wasn't until 10 months after it was granted that he went to the Conservation Commission, and it wasn't until 2 weeks before the expiration of the variance that he went to the Board of Health. So I would say that these provisions, the LAP provision is there to encourage people to exercise their rights and to keep these variances clear. And that didn't exactly happen here. He did get an A&R plan and had that, I guess, in place by August, but there wasn't much development at all until January or February in regards to the Board of Health and the Conservation Commission, respectively.
As a practical matter, there seems to be something unfair about the whole, legal structure, the scheme, the legal scheme. How do you, what could he, well, if he had recorded the variance, would that have done it? Would it have taken care of everything?
No, sir.
What else would he have had to have done?
You would have had to have substantially used the variance.
How could he do that without Conservation Commission approval?
Well, I would submit, Your Honor, that he should have moved immediately on that. I think he did.
What do you mean by immediately? Before he got the variance?
No.
No, afterwards. Once he had the variance, he waited 10 months before he went to Conservation, and then 11 months and 2 weeks until he went to the Board of Health.
So what do you want him to do, to move the next day?
I would say if I was relying on a variance and I had an economic opportunity, I think it'd be prudent to move immediately just to prevent this.
No, it may be prudent, but where does the statute compel that?
It doesn't compel it, Your Honor, but however, it does say that you have to exercise it within 1 year, and I don't think their conduct in this case.
So does that mean you have to have completed it, everything in 1 year?
I think that I would read it as meaning that you have to get your building permit and take substantial steps towards construction, either by laying your foundation, by excavating or moving equipment to the scene, or
How can you get a building permit without a Conservation Commission sign-off?
you wouldn't be able to. However, Judge, I would submit that
So say he'd file the next day and the Conservation Commission takes, I don't know,
10 months.
no, 15, 20, they take a long time. Serious issue.
and that is an issue I do admit. However, he did wait.
Yeah, but there's nothing that says he's got to go right now. You say you would do it, prudence, that's what's required. But I mean, I'm looking at statutes of construction. What tells me that he's got to do something? He sought an A&R, correct?
He needed an A&R, yes, Judge.
And he sought it.
He did.
And how fast did he sort?
He got that in August, Judge. I believe he
So how many months?
roughly 5.
When did he apply for it?
I believe in August or July. I'm not 100% sure.
I mean, how fast after he got the variance did he start to act?
I believe the record shows, Judge, that he consulted with his engineers afterwards, approximately in June.
And when was the variance granted? Forgive me, I've just forgotten the
The
date.
variance was granted May 7th.
So within 1 month, he's acting. Not bad.
But I would also add, Judge, that
May 7th or March 7th?
March 7th. I apologize.
I'm sorry.
I would also add, though, however, people know that boards don't move with light speed, and certainly,
Maybe the legislature thinks they do.
but waiting until the last 2 months, Judge, and then trying to, and then.
No, I understand. You saying, look, I as a prudent practitioner wouldn't have done this, but where in the law tells me that he's got to have gone the way you would go?
I would say, Judge, Section 11, which says it's not effective until it's recorded, is expressly within the law. One,
Well,
however,
that gets to a separate point. That's Justice Cordy's point.
How long did the Conservation Commission proceedings take?
those, Your Honor, I don't believe it was settled until the summer.
Following summer.
Yes, ma'am.
So it took,
I'd concede at least 6 months, Judge. I don't.
so if he had started the Conservation Commission proceedings in, say, in April, if the variance was granted in March, if he started the Conservation Commission proceedings in April and they took 6 months, it would have been within the year.
Yes, Your Honor.
But what do you do with our concern about the fairness of a process where somebody gets a variance, invests all that needs to be invested in the approval, but for reasons not of their own fault, they just don't get the approvals within a year, and then they have to beg the town to give them an extension? Isn't that basically the process which you're asking us to endorse?
Judge, that is a concern, but I don't even think you need to address that in this case because there was no extension requested as is expressly provided in for variances where it's not an option for special permits in the McDermott case, which Cornell asked this court to apply that standard. Additionally, before the court addresses McDermott, I'd point out that those cases are substantially different. One deals with special permits in Section 9, where variances deal with Section 10, and there are two different standards, one being exercise and the other being substantial use. And under the substantial use / special permit standard, you can't get an extension. However, with variances, you actually can request one, and Mr. Cornell didn't do that. And I believe the record shows that at the Board of Appeals, the follow-up request for a variance, he stated he didn't know that his variance had expired, and therefore didn't request an extension.
And you're saying he should have known because he didn't have everything done within a year?
Well, Judge, one, the law, I would submit, requires him to record it, but two, the variance itself, which is in the record, says you must record this, and he did not do that. I'd also submit to the court that the A&R, getting an A&R plan obviously doesn't relieve you from other responsibilities, as the court knows. You still have to seek a building permit. You still have to go to a number of other boards, which he eventually did, but I'd submit not in a timely fashion. And you also have to request an extension if you're not going to make it in enough time. And I would submit that preparatory steps aren't enough to actually exercise a variance. And to use an exercise analogy, you can't say you ran a marathon if you're just doing training for it or taking preparatory steps. The actual act itself would constitute the exercise. And in this case, he didn't have a building permit, he didn't lay a foundation, he didn't bring equipment to the site to excavate, and I would submit to the court that there's not enough here. Additionally, there was no recording of deeds or deeding out of the two lots, in addition to the fact that there was no building permit. And with all that, Your Honors, I would rest on my brief unless you have any other questions.
Have we, just one question, have you had, are there any cases that specifically deal with the word exercise of variance?
Not after 1975, when the lapse provision came into effect, Your Honor. There were some prior to 1975, which are cited in the briefs. However, after the provision was installed, which said you can ask for an extension and or it lapse after 1 year, there's no case law in regards to what exercise is for variances.
So it's not defined statutorily, and there is no case law putting a gloss on the word exercise?
Not under this explicit statutory provision, Your Honor.
Okay, so it's conceivable that the word exercise could be satisfied by obtaining an A&R, assuming it were obtained properly.
I would say no, based on the context, Judge. Obviously, the court can determine what it will in regards to this, but I'd say an A&R plan isn't a substantial act, so to speak, to trigger a variance or exercise it, which would mean getting a building permit or starting construction.
So you say you need to have the building permit?
I would say you would,
at a minimum.
Judge. Or do a substantial amount of work towards constructing.
In violation of the law that requires a building permit?
I wouldn't say to violate the law, Judge.
I'm trying to understand the same point. You have to get a building permit, and you say building permit or, and I'm thinking...
Yes, I agree. I agree with that.
Does the Dracut bylaw define excavation as an activity that requires a building permit?
It would require a building permit, Judge.
Okay.
Thank you, Mr. Hall.
Thank you, Your Honor.
SJC-10259, Feeney versus Dell.